Hi, everyone, and welcome to our webinar launching our first of its kind database studying risk assessment use and pretrial decision-making across the country. We're so excited to launch our website, Mapping Pretrial InJustice, a community-driven database. This webinar is co-sponsored by the Media Mobilizing Project, soon to be renamed the Movement Alliance Project, and MediaJustice as a collaborative project of the No Digital Prisons campaign. The purpose of this webinar is to introduce our website, pretrialrisk.com, to our community of people fighting pretrial incarceration in cities and towns nationwide. This site is the culmination of 3 years of research, a fact-finding mission into where pretrial risk assessments are deployed nationwide and how jurisdictions implement them on the ground. Thank you so much for joining us today. Now we'll briefly introduce our moderators. My name is Myasia Hayes, and I am the campaign director at MediaJustice, and I use she and her pronouns. For those of you unfamiliar with MediaJustice, we are a national organizing hub fighting for racial, economic, and gender justice in a digital age. We launched our No Digital Prisons campaign in response to the increasing presence of high-tech policing tools and algorithms that are being offered as solutions to end mass incarceration. Tools like electronic monitoring and pretrial risk assessments are placing another barrier between people of color and our freedom. These tools are false solutions and do not truly address the racial bias that exists in the criminal legal system. We are also the host of the nation's largest racial justice network, called the MediaJustice Network. And together we are working towards a future where everyone has sustained and universal access to open and democratic media and technology platforms. Our mission is to build a future in which people of color are connected, represented, and free. I'll pass it off to Hannah to introduce herself.
Hi, everybody. I'm so excited to be with all of you today. My name is Hannah Sassaman. I'm the policy director at Media Mobilizing Project, soon to be renamed Movement Alliance Project. I use she, her, and hers pronouns. And we work at the intersection of technology and racial and economic justice. And we've been lucky enough to contend with risk assessments as they've been deployed in Philadelphia, in Pennsylvania, and around the country for a few years now. And I'm really grateful to be learning with all of you today. And I'll pass it to Janessa.
Hi everyone, my name is Janessa Irvine. I'm a policy organizer at MMP, Media Mobilizing Project, along with Hannah, and I've been the lead community researcher who built most of the website and did a lot of the research for this site.
Great. So later in the call, we'll get to hear from incredible organizers and experts working at the intersection of technology, decarceration, and justice. For now, can each of you say your name, your gender pronouns, and the organization you're representing? I think we should start with Shakira first, then Lola, then Kathleen, then Alan and Rebecca.
Hello, everyone. My name is Shakira Cook. I'm the director of the Justice Reform Program at the Leadership Conference on Civil and Human Rights and the Leadership Conference Education Fund. The Leadership Conference is a national civil rights organization with over with over 200 member organizations that works to advance civil and human rights in the United States, primarily at the federal level. And we've been blessed to work in partnership with Media Mobilizing Project and MediaJustice on this issue, and pleased to be on the call today.
Hello, everyone. My name, is that?
Yeah, that's you, Lola.
Okay, cool. Hello, everyone. My name is Lola Rainey. My pronouns are she, her. I am the director of the Tucson Second Chance Community Bail Fund located in Tucson, Arizona. And we are fighting to end the state's carceral use of tools like cash money bail and risk assessments as we organize and build momentum to end pretrial detention. I'm also a regional organizer with the Criminal Justice Exchange, which is a national organization that supports local community organizers by developing and experimenting with tactical interventions as well as strategic organizing practices. And they create amazing innovative tools that are designed to end all forms of criminalization, surveillance, incarceration, and detention. recently, the CJE and the Media Mobilizing Project published a guide that I'm going to be talking about a little bit more in my comments that addresses some of the issues regarding pretrial risk assessments.
Great, thanks, Lola. Kathy?
Hi, I'm Kathy ONeil, she, her. I'm a data scientist and mathematician. I wrote a book called Weapons of Math Destruction, How Big Data Increases Inequality and Threatens Democracy. And I would say that the most serious and heavy and sort of deep and profound problems I found in the space of problematic algorithms, which is wide and deep, came from my study of predictive policing and these so-called crime risk scores, which I consider super pernicious and problematic. And I'm really, really grateful to be on this call. I also started a company called Orca, which is an algorithmic auditing company. And I do algorithmic audits of algorithms that people are concerned about for the very reasons that you guys are going to be discussing. So I'm glad to be here.
Thanks, Kathy. Alan and Rebecca?
Hey family, my name is Ilana Ramirez. I use they and he pronouns. I live in Asheville, North Carolina. And my role is bilingual regional organizer at Southerners on the Ground, LGBTQ liberation organization. And we've been throwing down on the Black Mamas bailouts for the past 3 years and excited to hear. Thanks for having me.
Hey everyone, my name is Rebecca Keel. I'm a Virginia statewide organizer with Southerners on New Ground. My pronouns are they, them, and theirs. I am based in Richmond, Virginia, but I'm calling in from Southside Danville, Virginia today. Thanks for having me.
Thanks, everyone. So before we begin, let's go over our agenda and logistical information about the webinar. Our agenda for today includes first, review the purpose of this webinar. Next, we'll share a little introductory background information on pretrial risk assessment tools and how they are part of pretrial decision-making process. We will then present some key findings from our research, followed by some highlights on a site that we have developed, pretrialrisk.com. Then we'll hear reflections from the amazing leaders we just introduced, all working at the intersection of the movement to end mass incarceration and data justice. Last, we will hear questions from you in our Q&A section. You can submit your questions or comments in the Q&A box at any time during the webinar. However, we're gonna hold on answering questions and comments from our listeners until the end of the presentation. Also, our webinar will be recorded and will be posted on MediaJustice and Media Mobilizing Project's YouTube channels for future viewing. As a note, there may be some journalists on this call in addition to the webinar being recorded. So any questions you submit will be considered to be on the record. If you want to have a discussion off the record, please contact us separately. For those of you on social media, please follow us at MediaJustice and at Media Mobilizing on Twitter and Instagram for live updates throughout the webinar. And finally, we will be conducting a few polls during the time of this webinar so that we can engage with you as much as possible. So right now, you should see, if you're on your computer, a box will appear on your screen. And you'll have 30 seconds to respond to the question. So let's try our first poll now. The question is, how familiar are you with pretrial risk assessment tools? You can answer very familiar, you can answer somewhat familiar, or not familiar at all. Thank you so much for completing this poll. It really helps us understand who our audience is today. So we'll give everyone a few more minutes to complete the poll, and then I'll share the results so you all know who else you're joining in today. So our poll results, about 31% are very familiar, 53% are somewhat familiar, and then 16% are not familiar at all, which is great. For those that are less familiar with pretrial risk assessment tools, we'll try to explain what they are and how they work, and we'll refer you to resources where you can learn more. Please don't hesitate to ask questions in the chat box or contact us after the webinar. And then for those of you who are experts, we hope to hear from you in the discussion.
Great, thank you so much, Maisha. So now we're gonna explain why we pulled together this research and ultimately created a database tracking the use and implementation of pretrial risk assessments. So nationally, there's been a surge in efforts seeking to end money bail and reduce pretrial detention. Places like New Jersey, New York, and California have all moved legislation focusing on massively reducing or ending the use of money bail, and dozens of cities nationwide have made similar commitments. In many cases, the solution that jurisdictions have put forth to ending money bail is a risk assessment tool, or a RAT. As most of you know, a RAT is an algorithm meant to guess whether or not a person will return to court if released pretrial, or if he'll get arrested again by the police in the community. Some see RATs as scientific, an objective way to only release people who will return to court and make sure the community is protected, or to assign supervision to quote unquote risky people. Many jurisdictions are implementing a RAT regardless of whether or not they intend to end money bail, because they view RATs as more fair than just a judge or a magistrate alone. However, we know that these tools can be problematic, based both on the factors they use to predict risk and how they're actually implemented in communities nationwide. These tools are used in many different ways all over the country, and there isn't a clear map for organizers to understand how RATs impact the pretrial process in their local area. So we conducted research to map out what goes into RAT algorithms, where they are used, and how they are actually implemented on the ground. We also wanted to investigate claims that these tools can reduce jail populations and or racial disparities in those jail populations, or in who's supervised. So we spoke directly to government employees who conduct or oversee the conducting of these actual assessments in their jurisdictions. And based on our research, it is not consistently true that these tools contribute anything towards reducing pretrial detention, increasing pretrial release rates, or reducing racial disparities in jails. We're particularly excited that this database is coming out just a few months after the guide that our comrades at Community Justice Exchange, where Lola is a leader, produced, that we helped to support at MMP. It's called An Organizer's Guide to Confronting Pretrial Risk Assessment Tools in Decarceration Campaigns, and it helps give organizers a sense of steps to take to contend with RATs in those campaigns. And we'll talk a little bit more about that later. So we're really excited for all of us to get stronger at confronting RATs as a part of the larger movement to end pretrial detention nationwide, and to give community organizations as much information as possible as they mount campaigns to challenge pretrial punishment in their cities and towns. And I see some questions in the chat box. We'll make sure that we put the name of the guide and links to the org right there. Thank you, Mariam, for handling that. So to the next slide, please. So what is a risk assessment tool? Simply put, they are algorithmic decision-making tools that use data points about a person accused of a crime to create a score meant to predict their likelihood of failure to appear in court and or getting arrested again if released pretrial. On this slide here, you can see an example of a tool used in one jurisdiction that we interviewed. This is Knox County, Tennessee. So the image shows both the risk factors right there on the left and the weight that each factor is given towards the final raw score on the right. Most risk assessments try to guess if a person will FTA, or fail to appear again, or NCA, meaning new criminal arrest, or get arrested again. They're sometimes trying to predict if the person will be arrested again with a violent charge as well. What happens next with the scores and how they translate into actual pretrial recommendations varies by the particular tool and the jurisdiction, which we'll get into when we talk about the research we found collected in our database. For most community organizations contending with how risk assessment plays into our work towards ending pretrial incarceration, just seeing this, just seeing a risk assessment and how it actually works is totally new. How jurisdictions use these tools is not something that's generally public or well explained even to the community directly impacted by pretrial injustice. But even beyond knowing what tool a jurisdiction is using, seeing the factors in a tool, how they add up to scores, we also need to understand how the tool actually operates in that jurisdiction, given their local pretrial policies and practices, what the results are, how those scores are used, how transparent it is to the public, and what actual measurable impact it has on the pretrial process and the population. So we're almost done with our introduction. We're about to go into some of our key findings that we have on the website. But we just want to note again, for organizers who use pretrialrisk.com to learn more about rats in their community, to find which one is deployed there, we really encourage them as a next step to go on to the Community Justice Exchange site and to start working through their guide on confronting risk assessment in decarceration campaigns. And you'll see the link right there in the chat box. And I'll pass it to Janessa.
Great. So next, we're going to share with you all some of our key findings from our research, and we'll get into our methodology a little later. So this map shows where we found risk assessment tools, or RATs, in use all across the country. As you can see, they're used all over. Our database tracks their usage in over 1,000 counties. And this map shows all the counties where we found using a pretrial risk assessment tool based on both primary and secondary research. We weren't able to touch every jurisdiction, but we look forward to growing this list. And pretrial risk assessments are not new. These tools have been in place in some places like Kentucky and Baltimore for decades. So as you can see, there was just a new poll popped up on your screen. If you had to guess, what percentage of the US population lives in an area where a pretrial RAT is in use? So go ahead and take a second and have a guess based off this map. Do you think it is over 20%, over 40%, over 60%, or 100%? So we'll give you just a few more seconds. I'm not sure what happened to our slideshow. Okay, so the results, 10% said over 20% of the population lives with a rat. 38% said over 40%, 52% said over 60%, and nobody said 100% because you can see that there are blank areas on the map. So good job. So those blank areas on the map show that either the jurisdiction doesn't use a rat or we didn't have information on them. And according to our research, of the 25 largest cities in the US, shown here as dots on this map, 23 of them are using a risk assessment tool. And since major cities and population centers largely are using rats, over 60% of the population lives in an area that does use a rat. So good job if you got that right, and I think the majority of you did. Great, so just moving to the next slide. Awesome. Our next findings concern the use of rats compared to claims that advocates of rats may make, that they can both reduce jail populations and racial disparities. So after full interviews with 38 jurisdictions and an additional 18 conversations with jurisdictions via email, 67% of those we interviewed were not able to share data about the impact a rat had on the size of their jail population. Only 9 of our interviewees stated that their jail populations had decreased since they started using a rat. Most of the others said that their population was static, or as mentioned, they could not give a definitive answer about how rats impacted the size of their jail populations. Some because there are just too many factors that might influence the size of their jails, but mostly because they don't track that information. And independent researchers have released data showing similar results. In the first year of implementing a rat, Spokane, Washington's jail population increased by 10%. Baltimore, Maryland has been using a rat for decades, and when they tried to limit the use of money bail, judges remanded more people without bail at all, resulting in a 31% increase in the average daily jail population between March 2017 and March 2018. Virginia was one of the first states that used a statewide rat, the Virginia Pretrial Risk Assessment Instrument, or VPRA. This graph on your screen, using data from the Vera Institute of Justice, shows that their jail population slowly increased after implementing the tool in 2005, and even after its first round of revisions. The pretrial population has fluctuated a little, but hasn't dropped significantly. Virginia does use a revised version of this tool now, the VPRA-R, but we don't have updated jail numbers through Vera past 2015. Because rats are algorithms and statistics-based tools, many feel they are more objective than judges or magistrates alone. They therefore may believe that rats have the potential to reduce racial disparities in jail populations. However, Megan Stevenson's report evaluating the impacts of pretrial risk assessments in Kentucky, which adopted a statewide tool early on, does not show this benefit. In fact, Stevenson found that the use of a risk assessment did not alter racial disparities in the pretrial population, and that the 2011 bail reform law mandating risk assessment benefited white defendants more than Black defendants due to the way that judges implemented these changes on the ground. Another researcher found that while before rats, the pretrial release rate in Kentucky was about the same for Black and white individuals, after rats became mandated, the release rate for white individuals was 10% higher than that for Black individuals. New Jersey is another example. In 2017, New Jersey completely reformed their pretrial system, removing money bail and requiring the use of the public safety assessment, a common pretrial tool. Their report evaluating the PSA's impacts at the end of 2018 found that although the overall jail population did decrease, the racial and ethnic makeup of the jails has remained static. Black and Latinx individuals still comprise about 70% of the jail population, despite only making up about 35% of the state population. In our interviews, some jurisdictions did speak to the need to reduce racial disparities and track racial population data in their jails. Some interviewees, like Connecticut, seen here, spoke about tracking racial populations and claimed that they are explicitly trying to reduce these racial disparities. However, many others, such as Armstrong County, Pennsylvania, Shasta County, California, and Yakima County, Washington, described how the tool was not intended to reduce racial disparities at all, or how race was not a part of the calculation because the tools were race neutral since they didn't explicitly mention race. As a reminder, this is what interviewees said at the time of the interview. We didn't back these claims up with separate research. And most importantly, none of the over 50 jurisdictions that we asked could give us any explicit data showing a change in the racial makeup of their jails following the implementation of a risk assessment. Moving to the next slide. All right, a key part of the impact that rats can have is how judges and magistrates implement them on the ground. We asked a few jurisdictions if they kept track of concurrence rates or how often judges followed the tool's recommendations. For example, releasing a person without conditions when that is what the tool recommends. Some jurisdictions stated that the court generally follows the tool's recommendations or that judges are using or consider using a tool. But most didn't have any data to back up this claim, and several jurisdictions said they don't track this. The Pretrial Justice Institute's 2019 scan of pretrial practices found that 73% of the 91 jurisdictions they interviewed use a rat to make a decision about release or detention, which they said raises legal concerns because detention decisions should be made through individual hearings with due process, not by rats. Risk assessment tools were designed to determine supervision conditions only. I'll note here that Arnold Ventures, which developed the PSA, now explicitly states on their website they expect tools to be used only to decide these conditions. The Pretrial Justice Institute scan also found that of the jurisdictions they interviewed that use a decision-making framework, which is a tool meant to help a pretrial decision maker interpret and apply the results of a risk assessment, only 52% actually keep data tracking how often judges' release decisions match the framework's recommendations. So we can't make claims about the impact that these tools have if they're not being used as intended and if jurisdictions don't keep tabs on how they're being used at all. Well, our interviews mirror some of the academic analyses of judges' lack of adherence to rat recommendations. In Megan Stevenson's report on Kentucky, she found that if judges followed the risk assessment's recommendations all of the time, 90% of accused individuals would be granted non-monetary release immediately. But in real life, only 29% were actually granted ROR, release without monetary conditions, at initial bail setting arraignment. In a study of Virginia's use of an algorithmic sentencing tool, researchers found that judges followed the tool's recommendations less than half the time. Another study in Virginia found that judges did not trust sentencing algorithms or weren't fully trained on them. A Maryland researcher suggested that you can have a lot of scenarios where the AI algorithms end up being a rationalization for what the judge wants to do. And one study on early use of algorithms found that judges were more likely to ignore the tool's recommendation for release than recommendations for detention, leading to an unbalanced tool impact that increases detention rather than decreasing it. Of course, how risk assessments are built and tested for accuracy matters as well. Understanding what goes into these tools and how they are validated as accurate or not helps us understand how they function and what kind of disparate impact they might have on those who are assessed. Even if rats are part of decarceration in some jurisdictions, this does not mean that every person accused of harm gets an individualized chance to fight for their freedom, as they're being assessed by tools that we know use biased factors and it might not even be accurate for what they're trying to measure. We gathered a wealth of data on the different input factors that these tools use. So it's time for our next poll, which hopefully you'll see pop up in your screen in just a second. Which of these demographic factors is commonly used in risk assessments? So go ahead and select if you think it's age, employment, housing, or substance use. And we'll give you a few seconds to fill out that poll, and then we'll wait for the results. All right, so we have our results. 50% said they thought age was used, 18% employment, 12% housing, and 20% substance use. So if we go on to our next slide, you can see the most common demographic and criminal legal factors we found in this graphic. And the poll was kind of a trick question because the answer is all of the above. All 4 of these factors, as well as many others, are used commonly in pretrial risk assessment tools. So these rats use factors like age, which equates youth with dangerousness, and lack of stable employment and housing, giving those living in poverty higher risk scores. Many rats also use criminal legal factors, such as prior arrests, which demonstrates the behavior of the police, not the person accused of a crime, prior failures to appear in court, which are often the result of lack of transportation or childcare, and even pending charges, which the person has not been convicted of, but still impact their score. None of these factors explicitly include race or socioeconomic status, but all of them are biased in terms of both race and class. For instance, we know that Black and Brown communities are subject to more surveillance and therefore more arrests, baking race directly into these seemingly objective factors. Rats are tested for accuracy through a statistical process called validation. We won't go into how that works now, but as you can see in this pie chart on your screen, from our interviews, many jurisdictions' tools were not validated locally or at all, meaning the tool that they used was probably built and tested on data from a different community, sometimes years or decades before, if it was tested at all. Statistically speaking, these tools tend to overpredict risk and overrepresent how likely the so-called pretrial failure outcomes are. It is difficult, if not impossible, to accurately predict these outcomes. So these tools and validation studies lend a false sense of scientific fairness to the pretrial decision-making process. And in our research overall, many tools' validation scores show that they were only slightly more accurate than the pure chance of a coin toss. We also want to point out that we spent a lot of time digging to find this information. We fully interviewed 38 jurisdictions, emailed over 530 others, and spent 3 years finding this information about what tools they're using and how they were implemented on the ground. Our team, made up of students, interns, fellows, and organizers, spent, as I said, 3 years finding this information, and we know that it is not complete or necessarily even totally correct, as facts on the ground change all the time. This data is not publicly visible in the communities that we studied, meaning there is a real lack of opportunity for community input into rats and pretrial decision-making policies and oversight. When jurisdictions didn't respond to us, we had to dig deep into secondary sources and ask other stakeholders to even find out what tools are impacting people accused of a crime, let alone who gets to see the results, how they impact the pretrial process, and whether or not they are doing what they claim to do. This has to change. Most importantly, we built this tool so that we can all more easily understand how rats work in perpetuating or decreasing pretrial detention and punishment. We aim to arm those fighting in the criminal legal sphere with the information and resources you all need when encountering risk assessment tools in the struggle to end pretrial detention. And after we understand how rats are deployed in our communities, we can take steps to design organizing campaigns that lead to the most decarceration possible.
Sorry, everyone, that's me. So now that we've given you a sense of our key findings, we want to take you through some highlights of our website, Mapping Pretrial InJustice at pretrialrisk.com. So as we go through the site, feel free to click around on your own. It's live right now. And add anything interesting or exciting that you find in the chat box, or put a question in the Q&A. If you have those questions, we'll do our best to address them later on. And I'll pass it back to Janessa to guide us through this site.
Great. Sorry, just want to make sure I'm not muted. Can you all still hear me?
Yeah.
Okay, great. So this is our website at pretrialrisk.com. This is the intro, and as you scroll down, you'll see the basics on each section that we have that I'll go into in a second. And I just want to spend a little bit of time here with our interactive map. I'm sure this is what many of you are excited to see. This tracks our research on risk assessment tools in action in over 1,000 counties across the United States. And this map is interactive, so if you click on any of the counties, you'll be able to see the name, the population, and what tool they're using. So for instance, if we click here on San Bernardino County, California, you can see that they have a potentially impacted population of over 2 million people, and that the risk assessment tool they use is the Virginia tool, the VPRE. And if you click here on this red button, it would take you to the page where you can download our data directly. I'm going to give you another example here, Cass County, Minnesota. You can see that they use a slightly different tool than the rest of the state. And we actually do have an interview with Cass County. So if you clicked on that red button, you'd be able to download our interview summary and learn a bit more. And if you wanted to learn even more specifics than that, you could go ahead and contact us. And you might notice that a lot of these areas are dark gray. And that means that as far as we know, those areas are pending or considering a tool. So as of January 1st of this year, 2020, New York State is just in the process of overhauling its bail and pretrial system. Many counties there used to use Compass, but it's no longer considered valid. So if you click on most counties in New York, you'll see that it says pending or considering a tool. And as we learn more information, we will be able to update this map to reflect those changes, and here in New York and anywhere else across the country. All right, so now I'm going to take you through the other sections in our site. This first section is the basics, and that shows you our basic information about how risk assessments work, what they are. You can see over here, I'm going to show you a little arrow. This section goes through the inputs that we were talking about, those factors that go into the tools. This section is the outputs and validation. This part talks about why some jurisdictions might opt to use rats. And this section, it goes through our argument about why we don't believe that rats will solve the problems of pretrial injustice. This section goes through common risk assessment tools such as the VPRE and the PSA that I mentioned earlier. And this section is our public safety simulator, which I will show you in just one second. So this allows you to experience what the PSA might feel like if you were arrested in New Jersey. So this allows you to choose an offense that someone might be arrested for, and then input information about yourself or a pretend person in order to see what the tool looks and feels like from the inside. And then after you select various answers to these questions, you will get a risk score in the 3 areas that the PSA calculates. And if you continued, you would be able to see what the recommendations are going forward from that. The next section is called the danger. And this section outlines in detail how bias pervades many of the common factors used in risk assessments that we saw earlier, both in terms of the criminal legal system and demographic inputs that they use. Our next section is called the impact. And this section explores how risk assessments actually work based a lot on our interviews that we conducted. So it goes through how risk assessments interact with the local policies, as well as with bail and incarceration. And then this section talks about transparency and how they're used. And this last part talks about how they may or may not impact pretrial populations and demographics, as we discussed already. The national landscape is where our map lives, which I showed you, so I'm going to skip that one. The take action section shows you some national resources in the get involved section, as well as tips on finding local organizers. Joining our listserv allows you to stay up to date and get emails from us. And then obviously you can always donate money. We're happy to accept that. And then last but not least, we have our research section. And this will take you through our purpose and methodology, as well as our interviews and database page. So this is where you can directly download our data. We do ask for some information from yourself, as you can see in this contact form. And then once you give us this basic information, you would get an email back with a link to download both our interview summary, which summarizes our 38 full interviews, as well as our database, which is a massive spreadsheet tracking the use of risk assessment tools in over 300 jurisdictions. And our reading list is a huge list of resources and secondary sources that we used across the site. It's very long, so feel free to explore if you want to learn more. And then lastly, our About section just gives you a little bit of information about the organizations and the people that put this website together.
Thanks,
So I'm gonna hand
Jess.
it back to you.
Yeah. So now we have some incredible local organizers, legal advocates, and data scientists who are excited to be part of this call and share their knowledge and experience around contending with risk assessments and pretrial decarceration campaigns, fighting to end pretrial detention, and fighting bias in algorithms. So we're gonna ask them to each speak for about 3 minutes or less so we can save a lot of time for questions from our listeners. Speakers, we'd love to hear your thoughts from you about what you've heard today or responses to these questions. The first question is, what is the stake that you or your organization have in ending pretrial incarceration and punishment and ending money bail? And how does risk assessment play into it? And then our second question is, how will this site and tools like this help you in your work and your community's work to end pretrial punishment in your community? I'll toss it to Sakira Cook first.
Thank you, Maisha, and hello again, everyone. And thank you, Janessa, for that great presentation of the website and the amazing research that you all conducted to continue to shine a light on this increasing problem of the use of risk assessment tools around the country. So the Leadership Conference over 2 years ago, almost 3 years ago actually, began a project to dive a little bit deeper into the racial justice, civil rights concerns with respect to the use of algorithmic-based decision-making tools or risk assessment tools. And it was a process that we convened with partners in the media and tech space and partners that work in the traditional justice reform space to look at the intersection of this issue and to really dive deep into what was happening in communities around the country. As we were seeing an increase in a call for the end of money bail, we were also seeing an increase in the call for an alternative to money bail, which was often couched as a risk assessment tool. So if we had to end money bail, we had to adopt in its place something that would give judges cover in order to make these decisions without money, right? Without a bail schedule, for lack of a better word. And what we saw was a proliferation of risk assessment tools as that alternative. So Leadership Conference with a number of organizations, including Media Mobilizing Project and MediaJustice, amongst many others, began an 18-month-long process of research, of conversation, of convening and meetings to develop a shared statement of civil rights concerns with respect to the use of these tools in the context of pretrial decision-making, because we feared, as Janessa's presentation and Hannah's presentation has articulated, we feared that people of color, specifically African-Americans and Latinos, who are overrepresented in jail and prison populations, would be disproportionately impacted by the use of a tool, and that these tools were not being were being pitched as objective, but were in fact not very objective and very subjective with respect to their application. So we developed a statement of principles to mitigate the harm that we believe could come out of their use in the context of pretrial decision making. And that statement was released in July of 2018. And it has six principles that we encourage jurisdictions to to dive deep into as they consider their use. And look, our statement starts off saying 100% that we don't believe that they should be used. We don't believe, full stop, that they are necessary in order to decarcerate pretrial, jails pretrial, and to address racial disparities. But to the extent, because we knew that they were already in use in many places, to the extent that your jurisdiction is going to use them, this is what you must do in order to address these civil and human rights concerns. And so our principles were signed by over 100 organizations that work at the intersection of this issue, that work on ending money bail specifically. And we hope that they will work in concert with this new website and with CJE's advocacy tool to arm advocates on the ground, to arm advocates around this country who are doing the hard work that it is to convince jurisdictions, to move jurisdictions, to force policymakers to do the right thing, to ultimately transform their pretrial justice systems, to decarcerate people, to decarcerate their jails, and to ensure that racial disparities do not persist. So we're excited to be in partnership with all of you and to put these principles to work, to put this tool to work, and to put the advocacy toolkit to work as we embark on some new work that we'll be doing in 2020 and 2021 with jurisdictions on the ground, with advocates on the ground, to put the principles in practice and to really have the principles reflected in the policy decisions that are being made in jurisdictions that are going to use tools, or to use the principles as a mechanism for pushing back on the adoption of tools in other jurisdictions. So I'll stop there, and I look forward to any questions that folks might have.
I just want to thank Sakura so much for that incredibly clear history and analysis. I'm just like reflecting on the incredible, rigorous understanding that so many of us have lent to this space and that we have taken from this space. And I now want to pass it to one of my favorite organizers in the country, Lola Rainey, just to share her reflections on her work and on this work we're all doing together. Lola?
All right, hello everyone. I want to just, talk about our experiences with the rats here in Arizona. And the first thing you need to know is that the Tucson Second Chance Community Bail Fund was founded in August of 2017 with the primary focus on ending cash money bail. What we did not know at the time was that the Arizona Supreme Court had already mandated the use of pretrial risk assessments by all courts with pretrial service capabilities in 2015. So a full 2 years before our bail fund was established, our Arizona courts had already begun to pivot away from cash money bail. And as an organizing group, that meant that we were not in a position to try to stop the implementation of pretrial risk assessments because that moment had already passed for us. And I think that's really that a number of you listening in today are going to find that's the situation you're in as you take up this issue. In fact, to really understand the impact and the challenges of taking on rats in your local jurisdictions, you're going to have to invest some time and resources in trying to figure out the history and evolution of rats, how they came to be in your jurisdiction. And then you have to do the hard analysis of whether or not rats somehow fits in your idea of your campaign to end mass incarceration. Now, the truth of the matter is there is no silver bullet, no easy way to decrease the use of or limit the use of rats and its impact on your pretrial court procedures once they're in place. That's just not, once they're in place, it's a difficult thing to unwind. And you also have to recognize that as organizers, you're going to have to approach this from a local perspective. One of the things that is great about the mapping tool that Media Mobilizing Project and MediaJustice created is that it is an excellent resource for people who are wanting to learn about pretrial risk assessments. It gives you a real substantive overview of what's happening nationally, and it gives you an opportunity to really look at what's happening, at how the tools are being used in a local manner. It also gives you an opportunity to see how diverse the risk assessment tools are that are being used. For example, in Arizona, we use the Arnold PSA, but there are a number of PSAs out there. And it's important for you to be able to look at that and really come up with an answer quickly of whether or not you have a RATS problem. And looking at what happened to us in Tucson, I think that we had to do a lot of this research ourselves. And so having this mapping tool available to you all now is a wonderful way for you to get a quick answer of, do you have an entrenched RATS problem, and so that you can start thinking about what you want to do. But another excellent resource tool is the one that CJE created along with the help of the Media Mobilizing Project. And that is the guide for organizers who are facing pretrial risk assessments in their decarceration campaigns. And what's really cool about this guide, this toolkit, is it gives you a framework for analyzing whether or not you really want to take up the issue of pretrial risk assessments, because the truth of the matter is we have so many challenges facing us. I mean, from mass surveillance and mass supervision, that whether or not you make dealing with rats a central part of your campaign is a decision that should be made after careful analysis. And I just want to end with just this one note, that I do think that the fight to end mass incarceration really is not simply going to be resolved by ending cash money bail or pretrial risk assessments or any other the carceral tools that the state might want to use. We cannot lose our focus that the challenge for all of us is ending pretrial detention, and that ought to be our focus. Thank you.
Lola, thank you so much. And thank you also to all of your colleagues and comrades at Community Justice Exchange for creating this guide, which we were really grateful to get to support. And we're really looking forward to hearing more about the organizing in Pima County when we get to questions. I'd love to pass it to Kathy ONeil now to lend her perspective as one of the preeminent data scientists and engineers and thinkers who are engaging and confronting algorithmic bias around the United States and around the world. Kathy?
Thanks, Hannah. So I have a lot of thoughts, and I won't have time for all of them, but I do want to just start by saying it's extremely important that this information is being made public and available to people. As a data scientist myself, it is shameful the extent to which this kind of work is proprietary and hidden, considering that we have due process rights in this country. None of this should be at all secret. We should be challenging all of the people that are using this, all of the data scientist companies that are making profit from this. We should be challenging them to give us evidence that what they're doing is fair, what they're doing is not racist, what they're doing has integrity statistically. And I really doubt that they'd be able to do that. I know why they're hiding. I think someone said it earlier, this is cover for the system to try to change. And sometimes that's held up as a good thing. We want to have cover so that we can decrease the population. But just speaking as a data scientist, I mean, when I say decrease the population, I mean of incarceration. Speaking as a data scientist, any threshold that could be lowered could also be raised. So there's a threshold that's lowered sometimes so that people sometimes aren't sent to pretrial detention. It could also be raised. So there's really no philosophical reason to think that making it a inscrutable algorithm is going to do anything to improve the actual system, except it's going to make it harder to understand. And to that point, I just want to mention two things. First, I've spoken to many judges who do not use this, and of course you've given statistics on the negative effects of what that means. It can mean that it just makes things worse for people instead of better. But I've also spoken to judges who just make the point, which is very true, that many of these risk scores simply are asking and answering the wrong question. For example, many of the judges I talked to mentioned that, of course, people will be rearrested, which is often what they're actually trying to predict, the risk of being rearrested. Many addicts will be rearrested, but the addiction is something that the judges claim should not be criminalized in the first place. So they don't want to be penalizing somebody for being addicted. So that's one point, which is that it's just literally asking the wrong question, and that has to be addressed and somehow has never been addressed The final point I'll make is that the data just isn't there. And when I talk about this, which I do frequently, maybe once or twice a week, all over the country, the way I say it is we don't have crime data, we have arrest data. And the idea that crime data equals arrest data is folly. And it's the missing data that the missing crime data, I should say, that we don't have. And I could talk about an hour about this, but the main point is that most crimes do not lead to arrest, but in particular, the distribution of the missingness is not equally distributed. So there's way more missing white crime than black crime. And what that means is that when you feed this so-called crime data, which is actually arrest data for the most part, into these algorithms, they of course, they predict that the police are going to go rearrest black people. So it is inherently racist because of the data itself. There's nothing a data scientist can actually do about that. So it's left to us to make the point that this should simply not be used because it's statistically unsound. And I'll stop there, but of course, I'd love to answer questions. Thank you.
Thank you so much to Kathy. It's really, really great to get your perspective and leadership. And I'm really excited now to pass it to Ilana Ramirez and Rebecca Keel at Southerners on New Ground, who have done such important work, especially in the South and especially with the National Mama's Bailout work in helping us truly understand the impact of pretrial incarceration on many of our communities. So please take it away, Ilana and Rebecca.
Hey everyone. So I'll tell you a little bit about Song. We are a 27-year-old LGBTQ liberation organization, and we're carrying on the legacy of our lesbian founders to use intersectionality in the building of strategizing for our organization. Because of that, we are members building a base across race, age, class, abilities, culture, gender, and sexuality in the South. And so the way we organize is taking on life or death issues that affect queer and trans people in the South. The past 3 years, Song members have been experimenting with a regional action of freeing Black mamas and caregivers from pretrial detention by fundraising to pay the bail the week of Mother's Day. Y'all may be familiar with this as the Black Mamas Bailouts. Through this, members come together, learn with one another, and stand up against the insidious police, court, and jail system of our local communities. So members who decide they want to take on this issue beyond Mother's Day can form a chapter with the support of our regional organization. And our chapters exist and are growing in Nashville, Durham, Atlanta, Wilmington, North Carolina, Columbia, South Carolina, Columbus, Georgia, New Orleans, Birmingham, Alabama, Greensboro, North Carolina, and a few others that we're planting seeds of. But any LGBTQ person or accomplices can join Song. So y'all sign up. I'm gonna drop a link. For the organization sign up. And so just the way, I'll quickly say, and before I pass on to Ilana, that we can use this tool that's being provided to sharpen our analysis and to build really savvy campaigns to win the demands of ending pretrial detention. And I'm just echoing what some other folks have said on that, but truly this big goal and demand is that we're focusing on is ending pretrial. And like I said, I'll drop our membership organization as well as me and Ilana's contact information. And now I'm gonna pass it to you, Ilana.
Yes, bro, thank you. Shout out to the Song family in the chat and everybody on this call. There's over 160 of us. There was 180 of us at one point. And so I just wanna take a moment to reflect and uplift the people, honor the people who have gone into the belly of the beast and actually have paid bail, posted bail for a loved one or for a friend, or for themselves, posting their own bail to buy their own freedom. I don't have a poll, but I can imagine a lot of us who are passionate about this would say yes as to I've been directly affected by pretrial detention. And so yeah, I just wanted to uplift that for the past 3 years, we've been holding Black Mamas Bailout actions in the cities in the South, thinking a lot about ourselves, really. So two of Song's core organizing methods are political education and direct action organizing. And so that means we are as members building ourselves up to be the abolitionist organizers that we need. And so I'm really grateful for the members on this call who've trusted us enough as like a scrappy ass organization. Honestly, we are a grassroots organization who is fundraising money to post bail without the guarantee that we're going to get it back. And so the learnings that we've gotten and the issue that we raised around bail has even now has been seen on the presidential slate, right? We see it in the presidential, this conversation around money bail being thrown around and brought to the mainstream. And so we're grateful for that. But in the South, we know that there's no easy way out, that no one's gonna save us from Oakland, unfortunately. And so when trying to figure out how we're gonna free our people, how we will end prisons and police as a whole, we understood that there's no easy way out. And so we took the road less traveled. And actually it's the road most traveled, because we decided to post bail and learn all the barriers that we actually face when we want to pay bail. And so we got good at that. We got good at knowing when and where we needed to show up to support our community. And we knew when and where exactly court was, where the magistrate's office is, where the jail is. And we knew that the week of Mother's Day that we're ready to reunite families, right? And so we're super excited for this launch and really thankful for MediaJustice, because we believe this is really going to help us elevate our campaigns this year. And we really want to see campaigns and build up the capacity to abolish bail. And so even though our scrappy bailouts have really worked, honestly, and have been a success because of all the learning that we've made and all the learning that we got, we're really excited this time to go in with more understanding, with more knowledge of the tools that are being used, the why and the how our people are put into the pretrial detention system. And so, yeah, we know that we're not okay knowing, that we have to show up for people's court or for their first hearing, but this time we want to show up and actually take on some of the tools ahead of time. And so, yeah, we're just grateful to be in community with MediaJustice and everyone on this call. And I want to challenge you to join us on the learning, join in and see for yourself what it takes to post bail. Share your story of posting bail. Share your story of bailing somebody out. And yeah, I just invite you to join Song. Come with a crew. Come with a crew to first appearance. Come with a crew to go court watch. Ask your jail, what are the diversion programs? What tools are they already using? And let's bail out some Black mothers and caregivers this year. So yeah, thank you.
Thank you so much. And I'll pass it to Maisha to go to the next section.
Sure. So at this time, we're going to open it up for questions from our listeners. Listeners, please remember you can type your question in the Zoom Q&A box, and we will answer them directly or pose them to one of our incredible speakers.
Great. So I think I just want to mark that we've been getting a lot of questions. It's pretty unlikely we're going to get to everything, but if you take a look at pretrialrisk.com, we have a contact form right there. I've seen a ton of things come through the transom that are about particular fights. I saw New Orleans coming from Bruce Riley. I saw stuff in Miami and across Florida coming from the Dream Defenders. That's exactly the kind of conversations we want to have, and we might not get to all of them right here on the phone. I saw questions about Puerto Rico, but that's why this database exists, so we can try to get you the information that we have, as well as connect you to others who can help you engage with these issues in your local fights. That's what we're here to do. So the first question that I want to bring up was asked by someone named Martha Gutenberg, and it was a question of who creates risk assessments? Is it US think tanks? What other countries use them? That's a question that I think a number of us can answer. So maybe Janessa, if you could talk a little bit about some of the major tools that we found used across the country. And then I'll also ask Sakira and Kathy if you have anything to add on who's making these tools and sort of what's the sort of financial backing behind them. We had a number of questions on that point.
Sure. So a lot of the tools, there's kind of a split between tools that are made locally for a specific county or jurisdiction, and a lot of times those are developed by the local jurisdiction contracting with somebody at a university or particular researcher. And then there's also these large national tools like the Public Safety Assessment, which was developed by the Laura and John Arnold Foundation, now called Arnold Ventures. Dr. Marie Van Nostrand has developed a number of different tools through different organizations, including Luminosity. Sometimes states, like Alaska's was developed by their Department of Corrections, probably in conjunction with somebody specific. But yeah, a lot of times they're contracted out to develop through a specific researcher.
Great. And one thing I can add to that as well is that the Community Justice Exchange Guide has a good history of some of the earlier experiments on risk assessment, including coming out of Vera in the 60s and experiments in New York. And there's a long history of these kinds of assessments just becoming more and more complex as we've approached, more recent decades. Most of them are not for profit. They're built by nonprofit institutions or universities, but that doesn't mean that they're not used by the prison industrial complex. So I want to pass it to Sakira and Kathy to see if they have anything to add about the developers of these tools.
I would just add that with respect to because I saw a question about monetization of tools and, whether or not there is a nexus between monetization and the proliferation of the tools. And I would say that while some of them are not for profit and are not being monetized in that regard, I think as they continue to be proliferated, you'll start to see, as we have seen with predictive policing tools, companies that will be lobbying governments to create line items in their budgets, right, for the adoption of the tools in state budgets at the federal level, et cetera. And so through grant programs, and that is how a lot of body cameras are being funded around the country, is through federal dollars that could be going to something else that are going there. And so people should be aware of that and should be thoughtful about that as they think about how the tools are adopted. Kathy?
Yeah, I'll just add that, just like every other algorithm that I can think of, like hiring algorithms or the algorithms that were being used to fire teachers all over across the country, the accountability tools, these algorithms typically are set up legally as a sort of a third-party vendor, data vendor, sort of writes an algorithm, has their own measurements of whether it works or whether it's fair, that they do not share. And the only they have a licensing agreement with the local government that stipulates that nobody in government will actually ever see the code, will actually understand why it works or why it doesn't work. So there's a lot of secrecy going on, which I don't know why is legal, because we have Freedom of Information Act laws. And I've talked to so many FOIA lawyers, and many of them tell me this actually should not be possible, that it's all secret. So that's like a long-term question I have about this. Like, how is it that our public taxpayer money is going to secret algorithms that no one understands and yet is being used to incarcerate people?
Thank you, everyone. Maisha, can you ask our next question?
Sure. There was a question here from someone named Sally G that was basically asking, shouldn't judges and their discretion be used to make these decisions rather than risk assessment instruments?
So that was a question about, judges and discretion. So anyone on the call that wants to take this, either someone who has really watched judges work with their discretion. I guess one thing that I'll say is that for a lot of us in the movement to end pretrial detention and end mass incarceration, the thing that we're really fighting for, like risk assessment's a piece of it, but really what we want is for it to be basically impossible, if you are accused of a crime or accused of harm, for you to spend a night in jail, for you to be held pretrial at all. We want to make the possibility of pretrial incarceration or pretrial punishment or supervision extremely small. So if a judge or a prosecutor truly wants to hold you for some actually provable reason, that decision is made through a fully blown hearing with a lawyer standing next to you in front of a judge rather than a magistrate, with evidence and the ability to sort of defend why you'll be safe in the community. The same kind of hearing any of us would want. And we're talking about limiting that net is really core to a lot of our fights. So it's not about judges versus risk assessment. It's about whether or not pretrial incarceration is even a thing. But I want to pass it to any of our other panelists to reflect on that question.
Rebecca from Song here. I'll just chime in with a bit of an anecdote I've been seeing in the courtroom. So I come from a background of social work, and then have been just doing court watch of recently. And something that's interesting about Virginia is in the, we use vPRE here because we made it. In the vPRE instruction manual / user guide that was written by the Virginia Department of Criminal Justice Services, it states the following: the practice recommendation concurrent rate for each agency must be 85% or higher. So what that means is magistrates, or the folks who like walk people through vPRE, have to abide by the vPRE recommendations 85% of the times. Now, when you're in an arraignment and the defendant is usually on video because they're locked up, at least that's the experience I've had in Virginia, the judge will take a look at what the Commonwealth's attorney is. In Virginia, we use Commonwealth's attorney instead of district attorney, but same profession. So what the DA is saying, what the vPRE recommendation is saying, and then the judge's own discretion. So what I've seen is like a mix of those three perspectives making a decision about someone being held in pretrial or not.
I was going to add to that in Arizona, what we have is the issue of secrecy, and the fact that most of the information that we're talking about is not disclosed, it's not part of the record, it's done in camera by magistrates. So the defendants who, like as you pointed out, or usually on video, are not aren't aware of what the reasons were for that. The judges made these decisions. But really you're dealing with the specific issue of judges versus PSAs. I mean, the real issue is, why are we holding people in pretrial detention, period? There is caging people in pretrial detention does not make us safe. So if the basis for this, it doesn't matter whether it's judges or PSAs, we need to ask ourselves why, as a community, why as a society, we think some people are entitled to freedoms and liberties and some people are not. And most of the people we're denying those liberties to are people of color or people who are otherwise marginalized. So that's the real conversation. And I would ask the person who raised this question to think about, what is going on in their community and why are we comfortable with the idea of having 60% to 70% of the people sitting in your local jail now in jail simply because they're poor. And that's not about justice. It's about social control, it's about economics, but it's certainly not about justice. And I think we ought to be concerned about that and look at the underlying reasons for this disparity and the treatment of people in our criminal justice system.
That's so helpful. Thank you so much to Rebecca and to Lola. I'm just going to move us on to our next question. And I just also want to preemptively apologize to people we don't get, because this is just going to be an ongoing conversation. So there was a really great question from Logan Kepke, who I know is one of the great researchers and senior policy analysts over at Upturn. And he asked, what research, if any, exists on how jurisdictions develop decision-making frameworks or release conditions matrices? And I think that that's a really important point we haven't gotten a chance to get too deep into on this call, but again, the CJE guide goes into some depth about. So I'll say one thing really briefly, and then I can pass it to others who are on this call. A number of different jurisdictions, after they run a risk assessment on you, they take the content from that, they take the numbers, the results, and they feed it into a policy framework called either a decision-making framework or a release matrix, which is really the result of a bunch of negotiations. Like, we talked to a lot of people in New Jersey, for example, and there was a big fight after they passed pretrial reform in New Jersey, coming from the bail bonds industry and the District Attorneys Association, to basically cut a vast raft of gun charges out of the ability to be considered based on the actual risk level that was assigned to the person. If you had a whiff of a gun about you, you lost a lot of access to being considered for pretrial release in a number of different kinds of ways. And you can see around the country in a variety of different places, a bunch of sort of negotiated policy frameworks that surround the risk assessment that actually are a bunch of negotiations on how that data can be used. Arnold Ventures has come out. If you go to their website, you can see that they are really focusing on a release matrix now. And they claim that their tool set is meant only to be used for release, even though we see judges and magistrates using these tools for incarceration all the time. I'll note that my favorite research on actually the implementation of some of these tools and whether or not they lead to release is by Upturn. And there's a great paper by Logan and by David Robinson called Danger Ahead, which focuses on the actual implementation of these tools in live jurisdictions and whether or not culture change and other kinds of reforms are leading to decarceration versus risk assessment. So I definitely recommend looking at that. But I just want to pass this question to other folks who've done some thinking about either release matrices or decision-making frameworks who might have an answer to this question. I don't know if Kathy or Sakira or Janessa, you have anything to add there.
I'll just say that in our website, in our research, we were able to collect some of these kind of decision-making frameworks. They're not super available online, the way that a lot of the tools are not available online. Some people did send them to us or pointed to them, but in terms of like how they're developed, that's not something that we've had really a chance to dive into, and maybe that's a good opportunity for future research, because as Hannah was pointing out, how these frameworks work is really important in terms of the implementation of how things get translated from like a raw score or a risk designation directly into what actually happens to somebody if they're arrested and accused of a crime.
Great. Is there any other response to this one? Or do we want to?
I'll just add that the long form of our principles goes a bit into decision-making frameworks, and I think it further underscores the point that we've been making about the use of these tools and the idea that they are objective when in fact ultimately the decisions that judges are making, the decisions that are being made with respect to detention or conditioning really boils down to a policy choice that people made who got in a room and said that 80% is going to mean X or 5% or 10% or 20, whatever it is on the chart is going to mean X. It's going to mean detain. It's going to mean release with some sort of condition or release ROR, right? And I think that further underscores the need for us to move to ensure that in the context of this conversation, we are keeping our eye on the broader goal, which Lola and Hannah and everyone else has said, which is to end pretrial detention, right? We have a fundamental principle in this country of innocent until proven guilty. There's a presumption that we are ignoring by detaining so many people pretrial, and that should not be. It should not be. It should not stand, and we should be fighting tooth and nail to create a new framework for pretrial justice that ensures release, right? That ensures 95% of people are going home, and that whatever limited use of detention happens, it is very narrowly tailored and ensures people's due process rights are being protected.
Awesome. Let's pass it back to Maisha for the next question.
So the next question is actually for Lola, Alan, and Rebecca. How are you planning to use pretrialrisk.com and the Community Justice Exchange Guide to inform your local campaigns to decarcerate?
Can you hear me?
Oh, there you go.
Can you hear me? Okay, cool. All right. First of all, I mean, unfortunately for us, the tool was not around when we first started doing our own investigation and research into risk assessments being used in Arizona. We did work with Hannah, and she was very helpful in us and helping us put together the data that we've used to sort of create our own campaign. So that's why I'm saying to all of you who are on this call that you are very fortunate now to have access to the type of information that we had a very difficult time trying to get. But the other thing is that I want to emphasize that your battle is still going to be local. So this is great information, because not only does it give you a broad perspective in terms of what's going on nationally, but also can give you some basic information about what's happening locally. But once you have that information, you then have to do this analysis of whether you want to engage in dealing with risk assessments as a part of your decarceration strategy. Because as I said, there's so many other issues that are out there. What we don't want to do is get blindsided by being sort of having this myopic view of what we need to do. Cash, money, bail, and then they throw out PSAs and they throw out something else, and we're chasing after state actors' tactics. What we really have to do is keep our eye on the ultimate goal, which is the end pretrial detention period. So whether or not you want to engage with dealing with the risk assessment, which in Arizona and Pima County, we are working on that, because we've decided that for us, this is a real important issue, but we didn't arrive at that very quickly. We took a lot of time to decide that this was an issue that was important to our community. But we all had limited resources and staffing. We're mostly a volunteer organization, so we can only take on so much. So I really do think it's important that you do a deep analysis of whether this is an issue that you want to take on. We're doing a number of things here. Mostly we're talking about educating our community about what the problem is, because a lot of people were unaware that risk assessments are in play. Most people don't have enough contact with the courts to recognize what this means. And because the courts are so secretive in the way they use this tool, it's not something that's, public knowledge. So we really are engaged in trying to educate people about what PSAs are and how it is being used as a substitute for cash, money, bail. But in our jurisdiction, they use both. So again, you need to look at what's going on in your individual communities, because you're going to find inconsistencies in things that will be helpful to you as you plan your strategies.
That was so clear and amazing, Lola. I cannot imagine a better answer to that question. So let me try to move on to the next one. So this is a really good one, maybe for Kathy, for you to start with, just because I know you're focusing really deeply, particularly on validation and on auditing. So a lot of times, and Brian Winters asked this question, and a few others put some questions out about this. A lot of times, a developer of a risk assessment will go somewhere and say, oh, it's validated. We validated this, that means it's totally fine. And we tried to dig into that a little bit in our research about what they meant by validation, how recently was it validated on local data. So Brian's question is how do we view the role of validation studies in this industry? Do we make them regular, independent? Do we publish them? Do we make them transparent? Some designers of tools do that regularly, some require it legislatively, but others don't share this kind of information at all. So we'd love to hear a little bit more about validation and auditing and what those terms mean in this context.
Yeah, okay, great. And you know what, there's actually been a pretty good standard set just recently by NIST. I don't know if you know about the facial recognition audit that NIST just came out with like a month and a half ago. So that what they did was they developed a way to audit, and we just to a little background, like facial recognition. My friend Joy Bolawini at MIT Media Lab was very active, has been very active, showing that typically facial recognition works a lot better for white men, for Black women, and et cetera. So it's like this kind of question of, for whom does this fail? Which is always my first question when I talk about an algorithm. So NIST sort of like side by side compared many different facial recognition softwares and published the results. And so, for example, Amazon recognition, Amazon refused to submit their facial recognition. So like that, from my perspective, that should mean that no one should ever use that ever for any reason. And of course, there's a very valid question about when should we ever use facial recognition, considering the problems with it. But just putting that aside, what I liked about the NIST report was it sort of clearly delineated what it was measuring, how it was measuring it, and compared the various different software packages side by side, and that's a good thing. And so, in other words, it explained, it open sourced the methodology, it open sourced the results. It didn't actually show any so-called secret sauce. And most of the companies that try to protect their trade secrets along these lines will say, oh, you can't like show our secret sauce. You can't like publish our algorithm. Well, the great news about the NIST report is it didn't do any of that. So no worries there. having said that, of course, I don't see any real excuse to have anything here at all secret because of the constitutional right to due process.
Right, right.
Now, I just want to mention that one of the things that is really tricky, and I don't want to sound like a broken record, but it is absolutely impossible to underscore enough that we don't actually have crime data. So the typical question that one asks and answers when you're a data scientist working on this stuff is it accurate? And that's really not the right question. It's not the right question to say, is it accurate in estimating who will be rearrested? Because we happen to know that the people who are rearrested in this country are profiled. So basically what you're asking is it predicting the police, not whether it's predicting crime.
Right, right.
So that's why I like, instead of saying predictive policing, I call it predicting the police. It's really, really important to realize that that's what we're doing when we build these profiling tools. Ultimately, I think my personal feeling is that the data is so bad, and that we only know the ground truth for like pot smoking arrests, because that's the one crime category where people will admit that they smoke pot but don't get arrested. Like, we know that whites and blacks smoke pot at the same rate, and black people get arrested 5 times more often. That's a 5-to-1 bias. And so I don't really think any data scientist who has integrity should ever claim that their algorithm works, because they just don't have enough data to make that claim. And so it's really, it's one of those things where you're like, on the one hand, I want to see public auditing. On the other hand, what I want that public auditing to do is to rethink through what are we actually going for? What is the goal here? Because the standard goal of making sure it's accurate, again, is just like, oh, are we accurately going to predict how the police will profile people? That's not the question that we should, well, it is an interesting question, but we should not shift the responsibility of like racist profiling of the police onto the individual and punish them for it, which is what we're actually doing. So what I would like to see is like a larger discussion of what would it mean for an algorithm like this to work? And the answer cannot be accuracy.
That's really helpful. So I think we're going to go to one last question, just because we're about to wrap up. And we want to make sure that we have time to share our contact information where people who want to get in touch and ask more questions. I absolutely promise that we copied every single question into a running document. So if you didn't get your question answered, you can follow up with us. We can get back to you. In particular, if you're like, I live in Miami and we think this is happening and you're saying this, and what do we do? Like, that's the kind of stuff where we absolutely want to plug you into more resources that we and that other comrades have. So the last question that I see here that I think we want to ask are, what questions are being asked in risk assessments that result in racial disparity? And that was a question from Winter Jones. And so I think there's a variety of people on the call who can answer these questions. Maybe Janessa, you want to start by talking about some of the factors in our tool that we saw that were really about demographics and that really were about asking some of those wrong questions. And then anyone else, either with like a local experience or one of our national leaders like Kathy or Sakira, can jump in. But maybe Janessa, you can talk a little bit about the data we found that was demographic.
Great. Yeah, thanks, Hannah. So like we said, you can't necessarily put a one-to-one relationship between one particular factor increasing or resulting specifically in racial disparity, largely because there's too many things going on between A and B that could make that happen. But in terms of the specific factors, pretty much all of them are biased in terms of race and class. And if you go onto our website and look in the danger section, it goes through an in-depth look at why that's the case. But if you look at something like age, it's saying that young people are more dangerous. And if you look at something like, a lot of the time they include age in terms of age of first arrest. And that seems like, oh, it's, you know, about everyone equally, but like because of the behavior of law enforcement and because of the way that certain communities are surveilled, if you're a young person of color, you are so much more likely, I don't have the stats in front of me, but you're much more likely to be arrested at a young age than if you're a white person. Like, that's just how our system is right now. And so something like age is going to disproportionately impact people of color. If you look at something like housing, you can look back at the history of redlining. If you look at something like employment, you can look at who is underemployed. And it's again and again, it's hitting the same communities. Communities of color and low-income communities are going to be disproportionately impacted and more likely to be falling in these categories like not having employment stability or not having residential stability. And those are things that bump you up and make you seem like you're higher risk. And the same thing happens when you look at criminal legal factors. Everything like arrest, like we've been talking about, like Kathy ONeil had mentioned, that's the behavior of the police. But also if you look at convictions, because most of the time, I think our data shows that like 90% of convictions come from like accepting a plea bargain. And a lot of the times the reason that people accept a plea bargain, regardless of whether or not they committed a crime, is because they're poor and they're stuck in jail on bail and they can't get out. And so it feels like a better solution to accept a plea than to be stuck in jail indefinitely until your trial. And so that again is impacting certain people more than others. So even something like convictions, that seems like that's a good way of quote unquote predicting risk of future arrests or criminal behavior, that is racially and economically biased. So I'll pass it to if anyone else wants to add to that.
I was just going to add one thing, and it was from one of the people that we bailed out, and he had a prior arrest history conviction, and he was picked up 10 to 15 years later on some other minor drug charge, and he went through the PSA process, and he said that he already knew that the profile was going to be bad because of the way the questions were framed. And he said to me, he goes, but they don't know the man that I am now. They don't know how much I've changed. Because the problem with this tool is that he says that they think my past history is, dictates who I am. And I think that's a real important point. I mean, because PSAs fundamentally say that there's no free will. Some people are not able to change or to do anything in their life that looks different than what these data points say. And that's just not the truth. I mean, free will, we all have the ability to change, to move in different directions, to change, transform our lives. And so that's one of the things I think that's most offensive about our reliance on these tools, is that we think that some people are not capable of using their liberty in a responsible way. And so we are denying them that right, that the ability to be, free citizens in this country. And I think that's what we pretty much have done. We've actually allowed the courts and judges who have a history of racial bias to now use this fake tool, a predictive tool that says people don't change. So some people don't change. They are a victim of their circumstances forever. And that's a really, it's just simply not true. And we need to challenge that. We really do.
If I might jump in, this is Kathy again. I just want to absolutely underline that comment. I'm actually working on a pro bono case about a guy who was put in prison for 40 years, did his time, was given parole, and now is being incarcerated indefinitely because of a risk score, which, by the way, the first 2 risk scores were not high enough. So they just kept on giving him risk scores until they got 2 high scores and kept him incarcerated. So it's really being done and to your point, like, he has the same risk score now. He's 60 years old that he had when he was put in prison and when he was 17. There is no change in that score. It doesn't give him any credit for 40 years of good behavior, which is outrageous. And so that's a really important flaw of all these scoring systems. But I just wanted to add, and I want to make it clear that I know very well about the Arnold Foundation pretrial risk detention. They've done a good job of trying to get rid of the really problematic attributes that are the profiling attributes that go into the score, like are you addicted, and did you come from this neighborhood, and did your father go to prison, that some of the really terrible ones have. But they still depend on trying to predict who's getting arrested. And at the end of the day, if we have police that are profiling people and finding crime only in certain areas among certain types of people, that the question of what they're optimizing to, it matters just as much as what the attributes are that they consider. And so there's no get out of jail free just because you are cleaning up the attributes. You also have to, you're still depending on the data of the system, and the system is a problem.
So we are at time right now, and I just want to pass it back to Janessa to close us out.
Thanks. So thank you all so much for being here, all your amazing questions and the great engagement we had in the chat box. This has been really, really wonderful. If you do have more questions, or you want information, or you just want to get in touch, like Hannah said, please contact us. You should see our contact information on the slide. And you can also always go to pretrialrisk.com. It's got a contact us section there. Before we close out, I would like to thank our panelists again, Sakira, Lola, Kathy, Ilan, and Rebecca, for all of your wonderful contributions. As I mentioned before, a recording of this webinar will be available. And another thing that we'll try to do is gather up those questions into an FAQ page that will be added onto our site. So thank you all so much for joining us for our webinar on pretrial risk assessments. I hope this has been really useful for all of you. Enjoy the rest of your week and have a wonderful week.